So again, welcome to the Division of Housing's Office of Rental Assistance monthly webinar. This month, we are going to discuss the important topic of reasonable accommodations and specifically how we utilize reasonable accommodations in our rental assistance programs here at the Division of Housing. So in today's training, we are going to discuss the different legislation, laws, policies, and regulations that are associated with reasonable accommodations. We're going to discuss a definition of reasonable accommodation and a few other definitions. We will talk about the specific Division of Housing processes and procedures related to reasonable accommodations. We will discuss the frequently requested reasonable accommodations that we tend to see in our housing programs, as well as share resources with you and provide an opportunity for you to ask questions. This slide just outlines briefly the different legislation, the different regulations, and the different policies that we will talk about briefly. Please note, I am not an expert in law and legislation, but when it comes to the program regulations that we follow here at the Division of Housing and our voucher programs, I have become very familiar with specific sections of legislation that impact our program. Specifically, we will discuss Section 504 of the Rehabilitation Act of 1973, the Fair Housing Act of 1968, but specifically the 1988 amendment, the Americans with Disabilities Act briefly, and then just for your reference, and these are included in the resource slides at the end, the Code of Federal Regulations that we use in our federally funded voucher programs regarding non-discrimination in federally assisted programs and the process and rules associated with live-in aids. And then finally, would like to refer you to the Division of Housing Administrative Plan, specifically Chapter 2 that discusses fair housing and equal opportunity. So let's start, not necessarily chronologically, but in a sense, yes. Section 504 of the Rehabilitation Act of 1973. This is the first civil rights law for people with disabilities. The Rehabilitation Act prohibits discrimination on the basis of disability in programs that are specifically recipients of federal funds. And this includes the housing programs, the Housing Choice Voucher Program, the COC PSH program, our Emergency Housing Voucher Program, our Veterans programs, and so on. Of course, we follow the same legislation in our other voucher programs as well. Section 4 of the Rehabilitation Act states that no qualified individual with a disability shall be excluded from, denied the benefits of, or be subjected to discrimination under any federally funded program or activity. And so each federal agency, in our case, HUD, has its own set of 504 regulations, which include the reasonable accommodation process and policy, program accessibility, effective communication for people with hearing and vision disabilities, and accessible new construction and alterations. Next, we're going to move on to the Fair Housing Act of 1968, but we're going to specifically talk about the 1988 amendments. So in 1988, Congress expanded Title VIII of the Civil Rights Act of 1968, which prohibits housing discrimination on the basis of race, color, religion, sex, age, or national origin to now include protections for people with disabilities. And specifically in the U.S. Code cited here of the Fair Housing Act, it makes it unlawful to refuse to make reasonable accommodations and rules, policies, practices, or services when such accommodations may be necessary to afford a person with a disability equal opportunity to use and enjoy a dwelling. And then I also included Section A and C because this U.S. Code does not only discuss reasonable accommodations. It also talks about reasonable modifications and accessible and adaptable housing design. And I show these three important laws and legislation to make the point that providing reasonable accommodations to our participants is not a division of housing policy. I mean, it is a division of housing policy, but we didn't come up with it. Because we are a recipient of federal funds, we have to make our programs accessible in any way we can to people with disabilities so that they can have an equal opportunity to access the programs that we offer. So it is our responsibility as the recipients of federal funds to make sure we are following the law and making our programs accessible to everyone. And I think it's important to have this legal background because, as we'll see in some future slides, if we deny a reasonable accommodation incorrectly, it has pretty big implications for us, not just at the state and program level, but on the federal level as well. And then finally, the Americans with Disabilities Act of 1990. This was a civil rights law that prohibits discrimination based on disability and provides additional protections beyond the existing legislation we just discussed. Specifically, Title III states that no individual may be discriminated against on the basis of disability with regards to the full and equal enjoyment of goods, services, facilities, or accommodations of any place of public accommodation. So think hotels, movie theaters, public transportation. This Americans with Disabilities Act took the laws that were in place and expanded it so that people with disabilities could access public places comfortably and be able to enjoy those same public accommodations that everybody else could. In addition to that, the Americans with Disabilities Act does include in-depth language and provisions regarding service animals. But we do also have information regarding emotional support and therapy animals that is also covered in Section 504 and the amendment of the Fair Housing Act. Just a reminder, we're not going to go into great detail about service animals, emotional support, or therapy animals, because that is not our area of expertise here at the Division of Housing, but we do offer resources if your participants have questions about having different types of therapy service for support animals in their rental units. So let's talk about definitions. There are a couple different definitions of reasonable accommodation based on the different legislation. However, I think as you'll see, they accomplish the same outcome. So under the Fair Housing Act, a reasonable accommodation is a change, exception, or adjustment to a rule, policy, practice, or service that may be necessary for a person with disabilities to have an equal opportunity to use and enjoy a dwelling, including public and common use spaces, or to fulfill their program obligations. The Fair Housing Act makes it unlawful to refuse to make reasonable accommodations to rules, policies, practices, or services when such accommodations may be necessary to afford persons with disabilities an equal opportunity to use and enjoy a dwelling in public and common use areas. So again, it's a federal law that makes it unlawful for our program to refuse to make reasonable accommodations when those accommodations are necessary. Under Section 504 of the Rehabilitation Act, the requirement to make reasonable accommodations applies to any changes that may be necessary to provide equal opportunity to participate in any federally assisted program or activity. This includes a change, adaptation, or modification to a policy, program, service, facility, or workplace, which will allow a qualified person with a disability to participate fully in a program, take advantage of a service, live in housing, or perform a job. So again, this is that requirement that requires us, a housing provider that receives federal federal funds to make reasonable accommodations available to individuals with disabilities. And when these forms of legislation discuss a person with a disability, here is that definition that they are citing. A person with a disability, as defined under Section 504 of the Rehabilitation Act and the Fair Housing Amendments Act, is any person who has a physical or mental impairment that substantially limits one or more major life activities, or has a record of such impairment, or is regarded as having such impairment. So this is our definition for a person with a disability as it relates to reasonable accommodations. So that was our legal support for why we offer and have a reasonable accommodation process here at the Division of Housing. Now, oftentimes we hear the question, and I think the question is asked earnestly in most cases, shouldn't we treat everyone equally? I do have experience working with some of our property owners and landlords in the past, where we have advocated for our participants to have a reasonable accommodation, for example, to pay their rent in a different way than the required online portal that they require their their tenants to use. And landlords have said, well, we can't do it differently for one person. That wouldn't be fair housing. Again, I'm not an attorney, I'm not a fair housing expert, but that is a red flag to me that this property owner or landlord may need a little education on what fair housing truly is. So we do often hear, shouldn't we treat everyone equally? Under these different forms of legislation, and specifically related to reasonable accommodations, it is okay, and it is actually required by law that we treat people with disabilities, quote unquote, differently under reasonable accommodation. Just some stats. 10% of all people in the state of Colorado are living with a disability. Within the rental assistance programs nationwide, 25% of the participants are people with disabilities. If you narrow that down to the state of Colorado, among all of the rental assistance program participants, 30% are people with disabilities. And then when you narrow it even further to the Division of Housing's rental assistance program participants, we have 85%, and I actually believe that number is higher now, but 85% of our participants are people with disabilities. That is intentional. We do utilize our resources with the intent of serving people with disabilities. So it is very important that we understand this legislation. Providing reasonable accommodations when necessary allows full access to a program that may be otherwise out of reach for individuals with disabilities. So again, shouldn't we treat everyone equally? This is a graphic that I use in this training often. It has changed through the years. If you've seen my presentation in the past, we used to have the one of the kids trying to watch the baseball game with the different size ladders, but with more education related to equity and justice, the graphic has changed. And so we just wanted to share this again. It gives a visual to what we're talking about, and shouldn't we treat everyone equally? So you see in the first square here, this is unequal. This is inequality. The tree is leaning. One child has access to the resources because they're on that side that they happen to be on. The other child does not. So let's talk about making it equal. Let's give both children the same resource, divided equally. Now they each have a ladder that's the same size. One child has even better access to the apples, and the other child still does not have access because the tree is leaning. So even with an equal opportunity and equal resource, they still can't access the apples. So then we look at the equity tab. This tab is not only dividing the resource fairly, but it factors in the differences that people might be experiencing. Think of differences such as race or socioeconomic or disability status. That's going to require maybe the resource be modified because of that status. And so in this tab, you see they each get a ladder, but one ladder is going to be taller so that the child on the right has better access to the resource, or equal access as the child on the left has. And I think ultimately, in the bottom tab, you see the graphic for what they're calling justice. Justice is called long-term equity, right? We can provide these tools, we can modify the tools, but ultimately it's the system that we need to fix. So very simply, we can provide the taller ladder, we can give help, but what we need to do is fix that tree so that moving forward, we don't have to continue to provide tools, we can just have a just system. And I know that's the direction that HUD is going, slowly getting there, but what helps us in the meantime is our ability to offer accommodations to our participants. So I hope this is helpful. I do really like this graphic. So now let's talk about the specific policy, process, and forms as it relates to the Division of Housing Programs. And it starts out with that verification of disability. So as you know, or hopefully as you've heard in the previous slides, a reasonable accommodation is offered to a person with a disability to help them access our programs and resources more equitably. So that means that we would have to know that a person is a person with a disability before we can move forward with the process. Sometimes this is obvious or a known disability, and the need for what they're asking for or the accommodation is apparent. If that's the case, we don't need to move forward with further verification. I can use a very basic and simple example of a person going into a leasing office and saying they need a wheelchair accessible unit. They need an ADA accessible apartment. And they are a person who is in a chair. And so we don't need to, or that landlord or a property manager doesn't need to put them through excessive paperwork to verify their need for that specific accommodation. So if something makes sense without requiring a ton of paperwork, then we don't need to continue to verify. Now, in often the cases that we work with, it's not always obvious or known what the disability is as related to the request that our participants are making. And so in those cases, we do need the family or the household to let us know that they require an accommodation. It doesn't always have to be in writing. They can verbalize that to us, and then we can help them put it in writing. The agency must then determine if the person meets the definition of a person with a disability. Again, our households are generally individuals who are receiving some form of Social Security income, in which case that verification is automatic. We don't need to move any further. However, in the next slide, we'll go into that process if they are not a person receiving Social Security income for a disability. But it also has to be stated or shown to you or us that the accommodation will enhance the family's access to programs or services. It's what we call a nexus. There has to be a connection. It has to make sense before we move forward with approving a reasonable accommodation. So again, if an individual is not receiving Social Security income and Social Security hasn't already done that verification of disability for us, we do require third-party verification obtained from a knowledgeable professional identified by the family who is qualified to make that determination. We are updating our administrative plan that's effective May 1st of 2024 that we are asking that if the knowledgeable professional works for your agency, for example, that they are not somebody who has who does not work to directly administer the housing voucher for the participant. That's been shown to be a conflict of interest in some cases. So we do ask that that third-party verification comes from someone who's not directly administering the vouchers for the household. The request is only for pertinent information needed to evaluate the disability-related need with the accommodation request. We don't need medical records, specific diagnoses, not necessary generally. Treatment information, we may receive that to make our initial determination, but please do not keep this in the housing file. We don't want this kind of medical confidential information to be in the file. It only needs to be evaluated once, and then we can redact, or better yet, remove that documentation from the file. So let's talk about the frequently seen reasonable accommodation requests that the housing providers or the public housing authorities receive, as well as just a few that our landlords are probably familiar with. So on our side, the most commonly requested accommodation, well, this isn't in order. I would say that our most commonly requested accommodation is probably for voucher extensions. But we do see quite frequently requests for live-in aids, for additional bedrooms for medical equipment, to rent from a relative, exceptions to our payment standards, or exceptions to our utility allowance schedule, voucher extensions, or the opportunity to utilize their voucher in a shared housing situation. And then again, our landlords see things like a request for an assigned parking space, and more frequently waiving a no pets policy, or waiving a pet deposit policy to allow a service or companion animal to live with our participants. And just again, I'm not an expert, I am not an attorney, but it is important that our participants and our landlords understand when it comes to a companion animal or a support animal, there is no requirement in the federal regulations or the state of Colorado that an animal be certified as such. Simply just a knowledgeable professional stating that our participants require the services of this animal. The animal does not have to go through any certain certification process. I think our landlords do often require that or request that, just an important, and again, we're not the attorney. It's probably, I'd go to that resource sheet that I provided from the Denver Fair Metro Housing Office, and I would refer your households to one of those resources so that somebody with a legal background can share that information with the landlord. So let's dig into what these common requests that we often see look like. So additional bedrooms. This can come in a couple different forms. Most frequently, it's with the addition of a live-in aid. I've also provided at the end of the slides a link to the specific federal regulation that discusses live-in aids. But our family that consists of one or more elderly, near elderly, or disabled persons may request that they be allowed a live-in aid to reside in the unit with them to provide necessary supportive services for a family member who is a person with a disability. It does go on to say in the regulation that a live-in aid cannot be a spouse, domestic partner, or significant other. And I do believe it says something like cannot be in the unit except that they're there to provide this live-in aid support to our households. So a parent with a child with a disability cannot be considered their live-in aid because they are the parent, right? They have to take care of that child anyway. So we cannot classify the parent of a minor child a live-in aid. Simply, we cannot consider a spouse either. Of course, spouses take care of their significant others. who maybe need extra support, but not as a live-in aid necessarily. And so HUD is very clear that the live-in aid cannot be specific family members. And furthermore, the live-in aid must use the subsidized unit as their only place of residence. So they have to truly live in the unit. They can't have their own residence and then come by maybe for 8 hours a day to assist our families. And this is because we are subsidizing an additional bedroom for that live-in aid. It is a cost. And because we are paying for that live-in aid to have a room, they have to live in the unit. We also see requests for an additional bedroom to store medical equipment. This is when a disabled household or person that includes a household that includes a person with a disability requires additional space to store medical or exercise equipment necessary for their disability. Now, again, we do require a knowledgeable professional to let us know that our households do require additional space for their medical equipment. And we will often request a list of what that equipment is, because there are some situations that do not necessarily require an additional bedroom. Depending on what the equipment is, we just need to see just a general list so we can make that determination. Again, we're talking about something that comes with a higher cost. And so to be prudent with our federal funds while also following the requirements of the different legislation, we want to make sure we're making the correct decision on whether or not to grant the additional bedroom. And something we'll talk about, excuse me, later in the slides is the need to have an interactive dialogue. Sometimes we will receive requests that don't seem reasonable. We'll often receive a request to say, I need an additional bedroom because I have service animal, and the service animal, I need to lock them in the additional bedroom from time to time. We can understand that. It's not, unless there's a really good case made, we can have an interactive dialogue that says, I'm not sure that your request necessitates that additional bedroom. However, let's talk about an alternative accommodation. Perhaps we can increase the 1-bedroom payment standard to offer you an opportunity to find a larger space because your service animal might be a large animal. And so we really want to discuss the importance of the interactive dialogue so that when our participants are making the request for an accommodation, it's the correct documentation provided and the appropriate request, so we can efficiently review and approve those requests. And as I mentioned, we do have a lot of requests for voucher extensions. So if a disabled household is experiencing difficulty locating suitable housing as a result of their disability, they may request additional time on their voucher. The initial extension request must be accompanied with the request for a reasonable accommodation form, explaining the nexus between the individual's disability and why they're having difficulty locating a unit before their voucher expires. And that needs to happen once, that providing that request for a reasonable accommodation form. The participant may then continue to request extensions as needed without having to complete that request for reasonable accommodation form again after the initial request. So we generally approve extensions for a set amount of time. And when that extension comes up on expiration, if our households are still requiring additional time to search, they can simply request additional time. We've got that request for a reasonable accommodation that was provided on their initial request sitting in their file, so we know this is a need, and they just simply have to ask for the extension and we can approve them without having them go through all the paperwork again. There are situations where an extension request may require additional documentation. Generally, if a person has been searching for a year and has not used their voucher, we might want to see where they're looking and what's been going on before we continue to consider voucher extensions. That's a long time for a voucher to go unused, but we want to make sure that the reason our participants are not successfully locating a unit for their voucher, maybe there's something we need to be doing to step in and help them with their housing search if their extensions have gone on past a year. Sometimes it's because they are in a medical facility or in another sort of rehabilitation situation, and we understand that. But sometimes there's other reasons. So we want to dig into where they're looking and some other barriers that they're coming across so we can help offer solutions in those cases. Renting from a relative. So according to HUD regulations, a subsidized household may not be related by blood or marriage to the owner of the unit they rent under the program. And exceptions may only be granted as a reasonable accommodation for a person with a disability. So here's an example where HUD has a very specific regulation, but they go on to say in their regulation that as a reasonable accommodation, we can grant exceptions to our regulation. In many cases, in some cases, let's not exaggerate, in some cases, the Division of Housing receives a request from our participants to accommodate a HUD regulation, not a Division of Housing policy. And in cases where the accommodation request comes in asking us to change a HUD regulation, we aren't able to approve those accommodations because it is a HUD regulation. What we can accommodate here at the Division of Housing is our policies and procedures. Now, again, here's an exception to that where HUD does say in their regulation, you can make an exception to this. So we're granting you that opportunity. So in no case, however, when renting from a relative, is a subsidized household permitted to rent a unit from a relative if the relative also lives in the unit. And I'm talking about the owner of the unit. So the owner of the unit is related to our participant and that owner lives in the unit, and there's no exception or no way we can accommodate that request. So we do ask that the owners provide verification that they do not live in the unit that will be assisted by the program. On one of the resource slides, we do have a link to our website. On the forms page, we have a whole drop-down section for our reasonable accommodation documents, and included in there is the rent from relative form. And I will back up, and it does sort of go along with this slide as well. If our participants are requesting a change to a HUD regulation that we cannot accommodate, we do encourage that request to go to HUD in some cases, and we can assist our households in providing them with the contact information of where they need to make their request. So for example, with an exception payment standard, this is also a common request that we receive because the cost of housing in the state, in the world, is high. Our markets are a bit out of control right now. So we do set our payment standards strategically, county by county, to make sure that our households can access 40% or so of the available housing stock. We do this while balancing the ability to continue to serve the same amount of people that we are serving. If we raised our payment standards to the maximum, which HUD says is 110% of their published fair market rent, and we did that in every county, we would probably end up serving half of the households that we're currently serving. So we try to be very strategic and fair in setting our payment standards. However, we do find in cases that households that include a person with a disability might need a different kind of unit or a specific neighborhood related to their disability where the payment standards just don't cover the cost of housing. So in those cases, we do offer an exception payment standard as a reasonable accommodation or a higher payment standard. HUD allows housing authorities to approve exception payment standards up to 120% of the published fair market rent in that community. And so we are able to do quite a bit with that limit. However, there are cases where our households do require a specific unit related to their disability, and the payment standard they need may exceed 120%. And in those cases, we assist our households by sending that request to HUD DC, the HUD office in Washington, DC. So it takes a bit of time to get those requests sent off and reviewed and approved, but it is something that we do. An example we're giving on what a disability suitable housing might be for somebody. A participant may require a first floor unit because of their disability. And oftentimes we find that first floor units cost more than second, third, fourth floor units. And so in those cases, our participants might make the case why they need the first floor unit related to their disability. And then we can go on to approve an exception payment standard. In the email that I sent with attachments for today's webinar, I included a 2020 tip of the day that we sent out that discusses the process when requesting an exception payment standard. It's important that when an exception payment standard is being requested, that we receive a full completed packet the first time. Again, if we are trying to approve an exception payment standard in-house, and especially if we have to send it off to HUD DC, HUD headquarters for approval, that could take a long time. And these units don't stay unrented. And so we want a quick turnaround with our requests so we don't, so our families don't miss out on an opportunity to rent a unit. And so we ask that when these requests come in, they come in complete with a hand calculated 50058. It could also be our Excel 50058 form, the RAFTA for the unit that they require, the utility allowance for that unit, and a completed rent reasonable certification form, along with the request for why this unit is required as a reasonable accommodation, because HUD will require all of these documents when we send the request to headquarters. So just refer to that tip of the day. If you are working on an exception payment standard, we do need all of these documents to be included. So, reasonable accommodation requests. When can a housing provider, in this case, the Division of Housing, deny a reasonable accommodation request? We talk about the importance of making our programs accessible and available to everyone, and the importance of approving reasonable accommodations. And, oh, I just had this information. We approve, or we receive and review on average, I think 1,200 reasonable accommodation requests every year. That actually might be a little low. And the majority of those requests are approved. So this is very important process, and we take it very seriously at the Division of Housing. And for the most part, we are approving the majority of the requests that come in from our participants. However, there are cases where a reasonable accommodation request may be denied. And the legislation does provide us with guidance on when a request can be denied. And so if a request was not made by or on the behalf of a person with a disability, it can be denied. A reasonable accommodation request has to be for a person with a disability to access the program. So if the person making the request is not a person with a disability, there is no reasonable accommodation that can be approved. If there isn't a disability related need for the accommodation, now they could be a person with a disability, but they're not showing us that nexus or that connection between what their disability is and the reason they need a specific accommodation. And then if the accommodation is deemed to not be reasonable, and we are given two different categories for why an accommodation would not be considered reasonable. First, it imposes an undue financial and administrative burden on the Public Housing Authority. And second, it would cause a fundamental alteration to the nature of the program. What's important here, and I've bolded, is having that interactive dialogue. Before we say denied, you are not a person with a disability, we might want to say, hey, is there a knowledgeable professional that could complete this verification form that tells us you're a person with a disability? If there's no disability related nexus to the request, we don't just say denied, right? We want to interact with that participant. Explain to me a little more. I'm not seeing the connection. Can you show me the connection? We might need to document it differently for the file. It's important that we have this interactive dialogue. And again, the example I provided earlier, we might not be able to approve the second bedroom because the request you made doesn't connect to the need for a second bedroom. However, we can maybe increase your one bedroom payment standard to allow you to find a unit that's a little bit larger. So we don't want to just red stamp it as denied. We want to make sure that our participants understand the reason why we're asking the additional questions. And ultimately, if it is denied, we want them to know that we made every attempt to understand the request. And at the end of the day, sometimes they just are denied. So the two different reasons to back up, when we determine an accommodation is not considered reasonable. The first is if it causes an undue financial and administrative burden to the housing authority. This is an action that requires significant difficulty or expense. And then the housing authority has to balance the burden to the agency with the benefit to the resident. So we're a large housing authority at the Division of Housing. It would be hard for me to justify something as being a financial burden because we are a large housing authority and we receive a lot of money from HUD to house our participants. So it would probably be assumed we have reserves we could use, admin fees that we receive that we could use. It would be hard for me to make a case to HUD that we couldn't afford to approve an accommodation for somebody. Some factors that I do consider: the cost of the accommodation, the financial resources that I have, and the administrative responsibilities that would be imposed because of the accommodation. So again, my undercounted example, I'm sure, of 1,200 requests that we receive every year. That's a lot, right? And those all come into this box. And then we're approving the majority of them. And that's because we know that we can afford to give somebody a second bedroom for a live-in aid. And then every year we just look at our budget and decide, can we put more vouchers on the street or not? Generally, the reasonable accommodations aren't a huge impact to our budget. It's the administrative responsibilities. Again, if the requests are coming in that require my staff to do hours upon hours of work every week for one file, I might consider that to be an undue administrative burden to staff. I have yet to see that come through, So I don't have a really concrete example to provide. So again, we are, we err on the side of approving a lot of accommodation requests, and I think it benefits our households for the most part. Another factor that would make a reasonable accommodation considered to be unreasonable is a fundamental program alteration or a change that would be so at odds with the purposes behind the rule that it would be a fundamental and unreasonable change. I do have a couple of real world examples, and for the most part, they are related to requests that landlords receive from tenants that landlords have been able to either deny or offer an alternative to. We did have a situation where a tenant requested their landlord provide them daily transportation services to their appointments. Because they did not have transportation to get to their medical appointments. But the apartment complex did not have that service. They did not have a shuttle or transportation for their residents. And so the landlord, although it came in as a reasonable accommodation and the person was a person with a disability that did require assistance, it's not the landlord's role to provide that accommodation. So the landlord was able to deny that request. We had a request that we, the housing authority, use our administrative funds to soundproof tenants' apartments because of a mental health diagnosis they had and the sound of their neighbors, causing distress. So the Division of Housing does not soundproof apartments. That's not what we do. We provide rental assistance. So we were able to deny that request, but then to assist that household and their agency on locating a unit. It was in a quieter corner of the building. That was our alternative, our interactive dialogue, to still be able to assist this individual who needed assistance. But we were not required to provide that soundproofing. Excuse me. And then finally, an example of a building that did not have staff on site every day, but we did have a participant with a mobility impairment who was not able to get their garbage to the dumpster because of their mobility impairment. And they requested that maintenance come by every day to take their garbage to the dumpster. However, they only had staff on site 2 days a week. So that interactive dialogue was, I'm sorry, we have to deny the request for daily garbage disposal. However, our alternative is we can come 2 days a week if you leave your garbage outside your door, and our maintenance can stop by 2 days a week to take that garbage for you. So just some examples of where we either have to deny or we can engage in an interactive dialogue to come up with an alternative accommodation to assist our household. So let's talk about the specific process. I did provide the Division of Housing process sheet for requesting reasonable accommodations with this morning's email. So you have access to that. But it starts with our participant making a formal request for the accommodation and completing the request for reasonable accommodation form. It's important that I note that when I say a participant makes a formal request, they don't have to come into your office or call and say, I would like to request a reasonable accommodation to modify a policy. Not that kind of formal request. They just have to make it known they need a change. Sometimes our participants can say the words reasonable accommodation. Sometimes they can't. Sometimes they can just say, I'm having a really difficult time coming into your office to fill out this paperwork. It sure would be helpful if someone could come to me instead, because I really just can't get out of the house. I think kind of opening your ears, hearing where our participants are asking for an accommodation, sometimes without using those words. There's still a person with a disability who needs a change to maybe the way we're doing business so that they can continue to participate in our program. So just learning how to hear the requests sometimes when they're not there. And again, we don't require that they provide that request to you in writing. However, it is very helpful for us to have it documented in writing when we're doing file audits. If there are complaints that are filed with the different organizations and we have to provide support documentation on our accommodation requests. So we do ask that you assist the participants in completing the request in written form. And we do offer a helpful form that I've highlighted in blue. And then when a participant says, I need a live-in aid, I need an additional bedroom for a live-in aid because I have these medical requirements or these needs related to my disability that require somebody to live in the unit with me. Or I need an additional bedroom for all of this exercise equipment for my physical therapy that I have to do. We need their knowledgeable professional to acknowledge that they also need this accommodation. And so we have a verification of need that we ask that the participant provide to their knowledgeable professional. Again, if that's not something they can do, you can get the contact information for their knowledgeable professional and send that form on their behalf. Once you get that documentation back, the request and the verification of need, you're going to send that completed request to your SPOC at the Division of Housing. We do ask that you look it over with your participant and help them make the request complete and before it's submitted again, so we don't lose time kind of negotiating back and forth. Oh, we need additional documentation here, or this wasn't signed here. So just really helping your participants, making sure their requests are a complete packet before they're submitted. Once we do have that paperwork, the SPOC will review the documentation to determine if the request is in accordance with HUD regulations and with our policy. They will let you know if additional documentation is needed. And then ultimately, like I mentioned, we make our determination in-house. If it's approved, you will get notification of that the request is approved. And then you, the housing agency, will go on to notify your participant that, hey, your request for this accommodation was approved. Now, if the decision is to deny the request, the Division of Housing will send that notification of denial directly to the participant, and we will copy you on that documentation. And additionally, we will make a notation in Elite using what's called the hot list. And I'll show you what that looks like right here. On that residential information screen in resident processing, you can see the hot lists where I've highlighted here. We go in every time a request is made for a reasonable accommodation, and we just simply say yes, and the month and year that it was approved, that's our title. Then you can double click on any one of those to see the specific information on what the request was, who approved it. And this is helpful tracking for us because we are often, this information is often requested by different organizations on the different accommodations we're approving. And so I just wanted you to see, we have a very handy place where we track that information. And then we have an annual requirement. Now, if a participant requests a reasonable accommodation, we know that sometimes that process takes a lot. Will the doctor ever respond to your email? I don't know. If they're like mine, maybe not really fast. It might take you a couple days, a week to track down the information that you need. We also know that disability doesn't often change. So if a participant needs an extra bedroom for a live-in aid this year, they're probably going to need it next year as well. What we don't want is an undue burden to our participants to have to go through that process every single year of getting all the documentation, having the doctor sign, the doctor's not there anymore. We don't want to require our participants to do all this work when the likelihood that their disability hasn't changed and the need persists is still there. We just simply ask that our households complete what's called a verification of continued need of reasonable accommodation at annual re-exam. We don't require anything from a third party, a knowledgeable professional, just our participants self-certifying, this is my accommodation I have in place. Yes, I still need it for another year. Thank you. Sign. There is one exception where full documentation would be required again, and that's if a participant moves to a new unit and the accommodation that they have on file was specific to their previous unit. So they needed an exception payment standard for this very specific unit that was located near their medical facility that they needed to go to daily or something like that. If it's a unit specific accommodation and they move from that unit, we may, in most cases, require them to start the process over if they're going to need another accommodation that's unit specific and they're moving. DOH policy process and forms continued. What does the Division of Housing do if they believe a reasonable accommodation request is not reasonable? That's when we're going to talk about that interactive dialogue. We may come back and say, hey, we're going to need a little bit more information about this request. If that information comes in and we're still not satisfied that there's a nexus or that what they're asking for truly is required as an accommodation, we may discuss an alternative accommodation. And we do this in writing. We say, you know, this is where the notification comes directly from our office to the participant and you are all copied. You know, we can't approve the request as written. However, we can offer this alternative. Sometimes there isn't an alternative and we just simply can't approve the request. The letter will say that as well. So again, if we can't reach an agreement through that interactive process, the accommodation has effectively been denied. The requester does have a right to appeal the decision, and they could ultimately file a fair housing complaint if they believe they were not approved for reasonable accommodation that they should have been. And that could lead to an investigation. There are unfortunately several examples of housing agencies across the country that have been investigated and were fined and found to be incorrect in their failure to provide necessary reasonable accommodations. I don't want to be one of those agencies. And so our process is very consistent when we review accommodations that on the surface aren't easily seen to as something we could approve. Oh yes, I think I do go on to talk about that. So in the complaint, if a complaint is filed that we failed to provide an accommodation that was required, anybody can be named in these fair housing complaints. Us, the Division of Housing, can be named, our landlords, our partner agencies, and then furthermore, individual staff can also be named. So the Division of Housing could be named in a fair housing complaint, or a participant could say, Catherine Helgerson with the Division of Housing denied my right to an accommodation, as well as you guys as individuals. So we do require that all accommodation requests come into our office so that we consistently review them, so that we are looking at them equitably. We have a process that we follow. Again, if our staff can't see that the accommodation could easily be approved and they might need more information, they might either come to you or it gets sent to a program manager for further review. Yep, sorry, I should have gone on to this slide. So all reasonable accommodation requests should be sent to your SPOC. under no circumstances are we asking our partner agencies to approve or deny accommodation requests. We want to make sure that the request is complete and includes all necessary information and documentation. Our participants are always able to request a reasonable accommodation. We shouldn't be discouraging them at your level, at the housing agency, or at the Division of Housing agency from making the request. And at no point in the process should a participant be told, I don't think that's going to be approved, so don't send it, or I wouldn't even request that, it probably won't be approved. I think as the coordinator or the housing staff who's assisting a participant in making the request, you might see something that is incomplete. You might see that the nexus is questionable or missing. And you can certainly say, I'm going to encourage you to write that differently, or I think you're going to need to make a different connection there before submitting it to the Division of Housing. But there should be no case where a participant is told, don't even make that request. There's no way they're going to approve that. Because any denial does need to come from our office. So the decision to deny a request for reasonable accommodation should only come from a Division of Housing program manager. If the decision is to deny, the program manager who made the determination will send the denial letter directly to the participant and a copy to the housing agency within 10 business days from the date the request was received. From the date the completed request was received, there may be some missed days in there if we need some backup documentation that was missing. The Division of Housing has implemented formal and consistent policies and procedures for reviewing reasonable accommodation requests. The Division of Housing will inform applicants and participants of the availability of reasonable accommodations in correspondence, and anytime a quote unquote negative action is being proposed. So for example, if they receive a termination letter or a tenant conference letter, we want to make sure that the reasonable accommodation information sheet is included in that correspondence so that they understand that they have a right as a person with a disability to request an accommodation, especially if there's a negative action being taken against them. That negative action could be a result of them not understanding a policy or a procedure. And we want to make sure that we offer them every opportunity to fully understand. If the accommodation is determined to not be reasonable, Division of Housing will enter into an interactive process or dialogue with the requester with the help of you all at the housing agency. Division of Housing and housing agencies will ensure that policies and procedures are adaptable to accept alternative forms of request. So again, if somebody contacts you and says in a roundabout way they need an accommodation, but they're not saying the word accommodation or they didn't put it in writing, we want to make sure we offer them an opportunity to express that request, and then we assist them in getting it in writing. And remember, a person with a disability is able to request an accommodation at any time to a policy or procedure at any stage of their housing assistance. So the next few slides include resources that are critical in the reasonable accommodation process. The first one is a link to our forms page on our website. And I've shown you just what it looks like. We have a drop down specifically for reasonable accommodation forms. It includes our Live in Aid reasonable accommodation packet, just that general information sheet that discusses their rights and where they can send requests for reasonable accommodation. The request form, the verification of continued need that they would do annually at annual reexam, and then that verification of need form that a knowledgeable professional would complete. We also have our rent from relative form. In addition, the Division of Housing is working on recording some short 15-minute or less training videos. We call them shorts about different processes. And right now we do have one for reasonable accommodation. And so I wanted to provide you a link to our YouTube channel where we have that reasonable accommodation training short. These are different resources specifically from the first three from HUD. On the first one is their joint statement with the Department of Justice on reasonable accommodations. I'm not going to say it's old. I think it's from 2007, which to me doesn't feel that long ago, but I know it is. But it's all still relevant and very good information. If you like to read where the basis of a lot of decisions and legislation occur, that's good reading for you. I've also provided links to the specific codes of federal regulation that address non-discrimination in federally assisted programs, as well as the live-in aid requirements. And then a link to where our admin plan is currently published, and specifically pointing out chapter 2, where we discuss fair housing and equal opportunity. And then a couple of additional resources that we provide. These are from 2017, again, not that long ago. The first one is a really, really good information sheet on emotional support animals. I know you guys probably hear a lot of, or get a lot of questions from your households about, I have, an emotional support cat or a therapy dog that I need help making my landlord understand it's not a pet. Again, we don't have I'm speaking for myself, I don't have the legal background to advocate legally, but I know where I can find good information, and then I can refer my participants to an organization that can help advocate for them. And then another, from that same organization, another good document, What Fair Housing Means for People with Disabilities. Again, just a broad overview, but I think important information for you all to have as people who work with participants, many of whom have a disability. Before I continue, I'm going to stop recording.